House Bill 1204 by Representative Eubanks and Senator Irving to establish the recovery of damages for necessary medical care, treatment, or services rendered.
Senator Irving, you're recognized.
Thank you, Madam Chair, members of the committee, and members of the Senate. This is a very simple bill. It's very succinct, and it's really just based on balance and fairness. The scales of justice symbolize an impartial weighing of evidence and facts in a legal case that's represented the idea that justice should be balanced and fair by considering both sides of a dispute equally. Essentially, that means that decisions should be made carefully considering all the information without bias. The scales of justice represent the need to balance the evidence and arguments from both sides of a case to reach a just outcome. The language of this bill is very short and very simple and very clear. It seeks to ensure that these scales are balanced based on facts and the exchange of actual damages incurred and paid. That's it. We know that rates are negotiated. We know that contracts are signed based for those rates that are negotiated. That's how medical billings, that's how medical claims, payments from third-party payers function in the healthcare world. So it's unreasonable then to ignore that this reality of negotiated payments, legal contracts, and actual receipts of bills paid with the ability to seek damages for a payment or claim that virtually never existed, that would be fair, because it's not. They're not balanced when you're seeking a monetary award that never existed and was never paid. This is highlighted in several court cases. And we have those examples. In Dale versus White, the plaintiffs claimed an amount of $8,900 and some dollars in medical expenses for an emergency room visit, but the statement from the hospital showed an amount owed of $0. The plaintiff didn't make any payments toward that amount and testified that they had no intention of ever paying that bill. But when the Arkansas Court of Appeals ruled, they actually ruled that then the hospital would have to pay that $8,937.95 because of the ruling in the previous case of Montgomery Ward in 1998. And that's exactly what this bill addresses. So the actual loss to the hospital was $17,875.90. Again, because those were never paid for the actual services rendered. The hospitals never paid for the actual services rendered, and they had to pay the medical expense that appeared on the paper. And that's a flawed ruling. I don't believe that's fair, and this bill seeks to change that. Currently, one side of the scales is out of balance. There's this added weight when damages that were never paid are allowed to be considered for recovery. What this bill does is rebalances those scales to ensure fairness. It's a mathematical principle of equality that we all accept to be truth. 5 equals 5, A equals A. Literally, that's what we're talking about. And that's the exact principle represented in this bill, stating clearly that recovery of damages for past necessary medical care, past necessary medical treatment, or past necessary medical services received includes only those costs actually paid by or on behalf of the plaintiff or that remain unpaid and for which the plaintiff or any third party is legally responsible. What this bill does not do, it does not impact other categories of damages. It is only specific to the category of damages of medical treatment, medical services, and medical care of what was past. So we should have exactly a receipt that shows what was paid. It does not impact all future medical costs as established at trial. It does not impact all lost wages, past and future. It does not impact all property damage. It does not impact all non-economic damages, including past and future pain and suffering, scars and disfigurement, a survivor's mental anguish, loss of life, or punitive damages. This bill does not impact subrogation or the made whole doctrine or the categories that I just mentioned. It is simply, succinctly focused on what was paid and that you can only recover what was paid of those medical care and medical treatments. And I'm happy to answer any questions.
Questions for Senator Irvin? I see Senator Hammer and Senator Payton.
Thank you, Madam Governor. Senator Irvin, just a few questions, if you would, please. I'd like to hear the answers in public format here. The issue of the uninsured and the insured being treated differently. I would like to hear your explanation on that, or your what's your reasoning on that, please?
I think that was really good testimony in the committee meeting about this. We want those cases to be treated the same. Right now, they're not. And so I think what we're seeking here is the ability for, whether you're insured or uninsured, you're actually going to be treated the same in those cases, because we're basing it on an actual receipt and exchange of what was actually paid, and not some inflationary number that just exists on paper, but that was never realized monetarily.
The current cases that are in court now, this is not grandfathering anything in. This is going to be to the future. Is that correct?
Again, this bill is super small and short and succinct, and there's no language that reflects that.
And then the last question I've got is this: is it the position of the insurance company? And I wrote these down, by the way. They weren't handed to me. Okay. Is this the position of the insurance? Is it the position of the insurance companies then that through passage of this legislation, how are they rationalizing that it's actually going to lower insurance rates? Because that's one of the comments made out there. Or would you speak to that, please?
I will speak to that, and I think that you and I, we've all lived through insurance and how rates are determined and how premiums are determined, and it's very rare that you ever see premiums that decrease. And I'm not here to pretend that, you know, this is one thing that's going to make a dramatic change. If that were the case, I'd love that. But I think it's important that it reduces the cost of business. That's why the NFIB, small businesses, support this bill. That's why the Healthcare Association supports this bill. That's why the Chamber of Commerce supports this bill, because the state of Arkansas needs a climate of being business friendly. We know that's important to attract jobs to our state, and this is one piece of that puzzle. And so, yes, it is very, very critical and important, and there's all kinds of impacts. If you don't have guardrails in place, there's all kinds of impacts in the litigious nature that is created in the state of Arkansas. There's all kinds of consequences from that. It's hard to put a monetary value on it, to be honest. But it is true. OB-GYNs, you do know we have a maternal health crisis in the state. One of the reasons why is because we have a shortage of workforce in OB-GYNs, because they are sued more. I think it's the second highest. I have the statistic here, but OB-GYNs are sued. You know, I think it's their second most frequently sued class of physicians in the country, resulting in exorbitantly high malpractice insurance rates. And so we are finding a lack of people going into OB-GYN because of those malpractice insurance rates. And so having these guardrails in place, will it reduce insurance premiums? I can't say that, and I won't make that guarantee. I mean, we do all kinds of work in EBD to try to lower premiums as much as we possibly can, but we also know that we do what we can to pass those bills with those hopes. And I think that's what we're here for.
All right, thank you.
Thank you for the question.
Senator Payton, you're recognized for a question.
Thank you, Madam President. Senator Irvin, I love short bills.
Good.
I really appreciate the fact
Good,
that
I'd love your vote.
I got out of our committee, and went to my office and decided to pull up judiciary, I guess is what y'all were in. And obviously a short bill did not mean short debate. But I'm going to try to ask a new question. It may have been asked before I tuned in and started watching the committee, but one that I'm not sure anybody has asked. And that is, even though it's a short bill, sometimes one word can matter.
Sure.
And there's a word that appears 3 times in here that caught my attention, and that is necessary. Mm-hmm. Necessary medical care, past necessary medical treatment, and past necessary medical services. And so I thought, okay, well, do we define necessary anywhere? So I pull up LexisNexis and start looking, and I don't see where it's defined in anywhere in this section of code. And so just thinking about it, I'm trying to figure, are we creating an argument, a new argument for them to have over what's necessary or not? Because from my understanding, you have somebody injured, they go to the doctor for treatment for that injury. Nobody's going to argue with the medical providers as to whether it was necessary or not. But when we put this word necessary in here, I think we could be creating an argument by the lawyers who I think after we've been down here 10 or 12 years, we should be able to take the bar and hang our shingle out, but lawyers argue as much as legislators do.
Yeah.
And I fear, I guess I'm questioning, why are we using the word necessary so often here? And medical services are not, or medical damages are not even mentioned individualized in this section of code.
No, it's actually a really good question, and it is an important word to use, because when you are looking at claims that are filed and bills that are, and how those are paid, it goes back to medical necessary. So because of our prior authorization landscape and all those kinds of things have to be considered medically necessary in order for them to be paid.
So who defines that, or who determines it?
Well, it's determined most likely, it's through your payers are determining that, which is why I've done a ton of legislation on prior authorization to limit those prior authorization policies and procedures, because it is determined medically necessary. But we do that in Medicaid, it happens in Medicare, TRICARE, any third-party payer.
So if I could follow up.
Yeah.
I understand what you're saying, but in this case, a payer has deemed it necessary and paid for it. Now we're arguing over whether or not somebody else is going to pay for that. And it seems we're creating room for that third party, the liable party, to argue, hey, that shouldn't have been done, it wasn't necessary.
No, well, that should have already been decided and resolved when the payment had occurred. So you're talking about past. I mean, and I think the important word in here is past. You're talking about something that we can see on paper. This is what was claimed, this is what was billed, but this is what was collected.
Do you think all insurance companies, all providers, and all payers always agree on what's necessary?
Oh, gosh, no. I mean, of course not.
So we've got a payer that paid it and said it was necessary, but we're asking somebody else now to pay for the same thing. They're going to have a different interpretation.
No, I disagree. I mean, I hear you, I disagree. I think, I disagree. The word is in there based on what is actual billing practices, and it doesn't have anything to do with what you're seeking or
thank you,
stating.
and thank you, Madam President. I would feel better if it was used in other places, but this is the only place it's going to be if we pass this bill.
Well, I would disagree. There are actually places all through our legislation as it relates to Medicaid where it's medically necessary, and EBD. We use this term quite frequently.
Okay, thank you.
But I appreciate the question. It's actually a very good point. Okay.
Any other questions for Senator Urban? Seeing no questions, anyone wish to speak against the bill? I see Senator Stubblefield to speak against.
You know, it's been mentioned that this bill was a simple bill, and it appeared so on its face because it was just a couple of lines, but in a whole lot of ways it was simple, but it's not simple in the fact that it helps the big insurance companies but hurts the little guy when he has to fight them. If you watched some of the testimony, the 2-hour testimony, or more than 2 hours yesterday, you heard some extraordinary stories about people who had been injured by someone else and who had to fight for their insurance, and then the other person come around and they discounted her insurance, so she would have to pay for part of his bill, and he was the one that caused the accident. So there's a whole lot of talk of things of this bill that it doesn't deal with either. It doesn't deal with rural health care, doesn't deal with inflated hospital billing, doesn't deal with lowering medical malpractice insurance. Families already spend a huge portion of their monthly income on premiums. They're paying for a lowered bill that their insurance company is supposed to negotiate for them. When something bad happens to them, that discount they prepaid with, their premium shouldn't go to the guy who is at fault for injuring them or to that guy's insurance company. Right now, under current law, that the benefit of that discounted amount belongs to the injured party because they paid for it and they are the victim. If we change this, then the insurance company on the other side is going to get to use what the victim paid in to reduce what they pay out. That's as simple as I know how to put it, and that's the simple part of this bill. That's a pretty good deal for the insurance companies. Collect and keep the premiums and now lower what they pay out. They say other states have done this. Well, there has been two or three other states done it. In fact, I spoke with one of the heads of one of these states the other day, Louisiana. He vetoed this bill. And you know why he vetoed it? He said, because it's going to hurt my people. We're here to take care of the people that elected us. I've learned this over a long period of time. There's a whole lot more of those people than there are insurance companies and rich people and logistics and all that. They say that Texas has done this, yet Texas insurance rates have continually went up. Their malpractice insurance rates have went up. They continue to go up faster than almost any other state. There's a reason there's not a groundswell of hard-working constituents here, because most of them don't know about this. They haven't a clue about this. And there's also a reason that room was full of trucking companies, insurance companies, because there's a big reason that out-of-state insurance companies want this bill. Let's put our constituents first. Let's put those people that voted us into office and we represent, let's just put them first, because they don't understand a lot of this. They're out working, and we're here to represent them. So I ask you for a no vote on this.
Anyone wish to speak for the bill? I see Senator, or you want to speak against? I see Senator Tucker, Senator Scott, and Senator Payton wanting to speak against. And Senator Penso. Senator Tucker, you're recognized, followed by Senator Scott, Senator Payton, and then Senator Penso. And Senator Clarke.
Thank you, Madam President. Now, I know I'm going to surprise everyone in here with this disclosure, but I'm a practicing attorney. So that's my disclosure to y'all today. And to more fully disclose, I have handled personal injury cases in my career. I've actually defended more of those cases than I've been on the plaintiff side, for what it's worth. So in my view, that doesn't give me a bias. What it does give me is expertise and experience. And what that expertise and experience has taught me is that no one in this room, none of y'all, want to trade places with an injured person, even with the law the way it's written right now. I'm going to talk a little bit about the way that this works. The first way is, and Senator Gilmore used a word in committee yesterday that I think is helpful, and that word is profit. Senator Irvin referenced the made whole doctrine. What the made whole doctrine means, which is the law right now, is there's no way for an injured person to profit off of their injury. Once they have been made whole, if there's someone, their health insurance carrier or whoever the case might be, if there's someone who has overpaid them some amount, then the extra amount goes back to the person who overpaid them. That's the way the law is written right now. So there is no profit to be made by getting injured. Now, the advocates for this bill will tell you that that money almost never goes back to the health insurance carrier. And that's true. The reason for that is because injured people are almost never made whole, because there are costs that go along with filing one of these lawsuits. Now, I wish we lived in a world where when you're injured by someone else and it's their fault, they did the right thing every time. But that ain't the world that we live in. And people have to hire lawyers in order to pursue their claims, and those lawyers have to get paid. Those attorney's fees are not reimbursable. That's just one big example of the type of costs that you can't recover, and which inhibit your ability to be made whole and to make sure you don't make a profit. Now, I know attorney's fees are part of the conversation in this. I just want to say, most of these cases are contingency fee cases, right? And y'all know that means that the lawyer takes a percentage of the recovery. A couple things. Number one, if you think lawyers get paid too much, That's not really what we're talking about. But by definition, if a lawyer's getting paid on a contingency, if their fee goes down, then the injured person's recovery goes down, by definition. And the reason why we have the contingency fee structure is because, and the reason I say this is because I want y'all to think about who these lawyers represent. You think about the lawyers, I want you to think about who the lawyers represent. The reason why we have contingency fee cases is because people can't afford to pay out of pocket up front. If they could, then they would. And this is the only way they get access to justice. Another way this works, Senator Ervin mentioned this. Medical expenses, right or wrong, this is just the way that it works in real life. Right or wrong, medical expenses are really the baseline for the value of these cases. And they impact every other element of damages, particularly non-economic damages. Now, Senator Ervin is right in that this bill doesn't directly affect those other elements of damages. And I know she believes, and I trust her with all my heart, that this won't affect those other elements of damages. But I also trust with all my heart that in the real world out there, this is going to affect all the other categories of damage, including non-economic damages. So the vote that we cast today, if this bill passes, it's going to lower the value not only of the medical expenses, but of other categories of damages as well. Now, what we are hoping happens if we pass this bill is that costs will go down, right? Now, if you believe that costs are going to go down if we pass this bill, I got some things that I'd like to sell you when we go back into room 309 or the quiet room when this debate is over. Let's just talk about that for a second. In Arkansas, I pulled these numbers from the Arkansas Insurance Department. Over the last 5 years, private pay, passengers, insurance companies, profit, this is combined over a 5-year period, $3.5 billion. That's the difference between the revenue they collect from insurance premiums and the cost of the claims they pay out. Now, Senator Dees made the point in committee yesterday that, companies should be able to make a profit. Fair point. So let's look beyond just the raw number. That's a 49% profit, 49% on private pay auto over the last 5 years. Pretty steep on the backs of the people of Arkansas. You go to commercial auto, the total number over a 5-year period is just under $900 million. Profit margin on that, 63%. 63%. And that's what we're talking about when we look at the macro of this. The costs of society are too high. It's indirect costs, and we're really talking about insurance costs. So if you think that costs are going to go down, it's like spitting in the ocean. What we're counting on in this bill is hope. We're going to hope, I said this in committee, maybe this is a bad example. What we hope is if we pass this bill is that Ebenezer Scrooge is the same thing that happened to him after he saw the ghost of Christmas future. That's what we're hoping on. And also, just for the record, this law has been in place in Texas for over 20 years, right? Medical malpractice rates in Texas higher than they are in Arkansas. So Senator Ervin talked about the scales. So on the one side, that's who we have, these insurance companies. On the other side, we have people who have been injured through no fault of their own. And I want to talk for a moment about what a tort is, because we talk about tort reform. I think it's important that what a tort is does not get lost in the discussion. In 100% of tort cases, not 80% or 95% or 99%, 100% of tort cases, someone was injured and someone else was at fault. If those things aren't true, there's no liability. And when we think about torts, a lot of times we think about the most common example is a negligence case. And the most common example of a negligence case is a car wreck. That's what we think of. But there are all kinds of tort cases. There are strict liability tort cases, most commonly with products liability. So you're in a car, you don't have a wreck. Your car catches on fire because of a defect in the product. Your family's in the car. They're caught in a burning car. That's a tort. This bill applies to that claim. There are also intentional torts. A fancy name for kidnapping is false imprisonment. That's a tort that this bill applies to. Battery. I can beat someone with a baseball bat or shoot them. That's a tort. Now, that creates criminal liability, but it also creates civil liability. This bill applies to that as much as it does to a car wreck. Child sexual abuse, that's a tort. This bill applies to that just as much as it does to a car wreck. So, on the one hand, we have these insurance companies or these big conglomerates. And on the other hand, we have people in every case who have been injured, and it's someone else's fault. Now, you might there's an argument, Senator Irvin's making an argument, and you may agree with her, that the scales are currently imbalanced. But whether you believe that or not, there's no question that what we're doing is changing those scales. The ledger in this bill is moving in one direction only. And it's moving away from the people who were injured through no fault of their own, and it's moving toward the people who injured them and their insurance carriers. Now, there are people outside this room right now who really want this bill to pass. They're doing their job. They're representing their industry. I got no problem with what they do. They've got a job out there. We got a job in here. Our job in here is to sift through who we want to be winners and losers on the bills that we pass. And on the one hand, you got the insurance companies with the billions of dollars in profits and in the faint hope that something may happen if we pass this bill. And on the other hand, we have our constituents in every single one of our districts who have been injured through no fault of their own. And that's who I'm going with, so I'll be voting no.
Thank you, Senator Tucker. Anyone wish to speak for the bill? I know we have several to recognize to speak against. Anyone wish to speak for at this time? If not, Senator Scott, you're recognized.
Colleagues, I rise today in firm opposition to House Bill 1204, not out of partisanship, not out of personal gain, but out of a deep and unwavering commitment to the people who sent me here, the everyday Arkansans who deserve justice, dignity, and fairness under the law. For 6 years, I was on the Judiciary Committee in the House of Representatives, and I fought tort reform every year because I've seen firsthand who wins and who loses when we chip away at the rights of the people for the favor of the powerful interest groups. I didn't run for office to protect the corporate bottom lines or to make it easier for businesses to avoid accountability. I ran for office to be the voice of my neighbors, of my constituents, of my veterans, of the families who have loved and lost a loved one due to negligence, and for the students who will inherit the state we shape today by the decisions and the votes we cast. House Bill 1204 is not about fairness. It's about shifting the power away from the people and into the hands of those who already have enough. You just heard the margins from Senator Tucker. It limits the ability for Arkansans to seek justice when they've been wrong. It tells the workers who've lost a limb on their job that their suffering has a price tag and that it's convenient for the company, but it's not for Arkansans. It tells the grieving mother that no matter how gross the negligence, there's only so much accountability we're willing to pay and allow for. It tells our most vulnerable that their pain is just a cost of doing business. And that is not the Arkansas that I believe in, and that is not the justice system that I swore to uphold. Let me be clear, Arkansas deserves better, and I will stand up for Arkansans even when it's not politically convenient. I am not beholden to any corporation, and I will fight even though I'm in the super minority in this chamber, even when the odds are stacked against us. I will not stop raising my voice because Arkansans deserve a quality of life that is not dictated by corporate interests in this state. I urge you, do not turn your back on the people who trusted us to do what's right for them. Reject this effort to weaken their rights and limit their justice and silence their voices. We are elected to serve them and not corporate interests. And with this, I ask you to please consider voting no on this bill.
Thanks, Senator Scott. Anyone wish to speak for or on the bill? If not, Senator Payton, you're recognized to speak against.
Thank you, Madam President. Colleagues, you're going to want to pay attention because I may say something really stupid down here. I've been down here a long time, and like, as I said a moment ago, maybe we should all be able to get a law degree after being here for a while. But the bottom line is, I don't want to be repetitive, and I don't want to be redundant. We don't like to sit there and hear the same thing over and over again. And this may be really stupid, but this is what I see that is different from what has been in the conversation. I become aware of this bill while it was still over on the House side because a couple of House members were asking me what I thought about it. I didn't hear from the lobbyist first. I got the bill, read it, it's short. I love short bills, and I didn't understand a thing that I was reading. I have an attorney that I've done business with for 20 years. He's on retainer, takes care of business law. I sent it to him. He read it at 9 o'clock at night, and he replies to me and says, well, I don't know exactly what it's doing. It's not taking a very big bite of the apple, doesn't look like to me. The other thing is, for 10, 12 years I've been down here, if you said tort reform, I was automatic yes. That's my default position for tort reform. And here's what I've learned. If I ask my constituents, do they like politicians? They hate politicians. But they like me. And if you ask somebody, do you like attorneys? They hate attorneys. But they like theirs, right? And regardless of what we do with this bill, there are attorneys on both sides. The businesses or whoever it is that's liable has attorneys, and the attorneys that are fighting for whoever was injured, some of those attorneys are paid on a commission. Some of them are on salary or on retainer. Is that what we should be looking at when we're trying to decide yes or no? So after listening to the committee on my computer rather than eating lunch, and I really appreciate those committee members that sat there and allowed this bill to continue for 3.5 hours and get it done rather than putting it off. But anyway, I pulled up the bill, and as you heard earlier in my question, I saw a word that I didn't like being in there, and I thought, well, if they took that word out, would I like the bill? Should I ask for an amendment? Because I really think we're creating more jobs for more attorneys, more hours for more attorneys when we put the word necessary in there and let them argue about what's necessary and what's not. I really believe we're going to drive the cost up more than we drive it down, because now those attorneys are going to have something new to argue about. But I couldn't vote for this bill even if you took the word necessary out. And I'm going to tell you why. If you pull up your LexisNexis, this is 1664-120. That's chapter and verse, okay? When I'm reading my Bible and I'm trying to figure out, I'm stumped on a verse, I'm trying to figure out exactly what it means or whatever God's saying, I have to back up and read a couple verses in front of it and a couple verses behind it. So that's what I did. I pulled up 1664-120, which is the section that this deals with, and I was pleased. It's one sentence. And if you look at your bill, it's there. It's before we modify it, before we amend it. It says, whenever damages are recoverable, the plaintiff may claim and recover any rate of damages to which he or she may be entitled for the cause of action established. It says whenever damages are recoverable. It doesn't say medical damages. It doesn't say property damage or whatever. I mean, it just lumps it all together, damages. You look at your bill, and the paragraph we're adding is all about medical damages. And I thought, well, do we define the necessary? Do we define the medical damages? So I back up to verse 19, and you know what it says? It's all about how the jury's going to reach a verdict. The verdict has to be unanimous. When they come back in and hand down their verdict, either side can ask for the jury to be polled. They'll be asked right there in front of God and everybody, do you vote yes or no on the verdict? Are you in agreement with the verdict? And if it's not 100% unanimous, then it's not a verdict. Now here we are sitting in the legislature, and we're going to try to influence how that jury decides. You go to the verse just past it, 121. Now it just got through saying any damages, and then in 121 it says, when by the verdict either party is entitled to recover money of the adverse party, the jury in their verdict must assess damages. So the jury has to be unanimous, and it gives the duty of assessing damages to the jury. And I don't think as a legislator, I want to sit down here and throw a blanket over that. I want the jury to have the ability to look at each case on its merits and decide what they're going to award. They have to be unanimous. It's not arbitrary. And I just don't think we should be weighing in on it. But if we do, we need to get that word necessary out of there so we don't create new grounds for new lawyers to make more money arguing over what's necessary. I'd appreciate a good vote. Thank you.
Anyone, thank you, Senator Payton. Anyone wish to speak on or for the bill before we go to the next senator to speak against? Anyone wish to speak on or for? Not, Senator Penzo, you're recognized to speak against.
Thank you. I've got a friend that's a bit of a character, and he said, "This is a real simple bill, but you need to change the title. It's wrong." And I said, "What's it need to be titled?" He said, "You need to change the title to the Insurance Enrichment Program," because that's exactly what House Bill 1204 is. I've had a lot of calls from constituents on this, and not a single constituent has called me and said, "Hey, I think it's a good idea that we take money out of the pockets of the insured parties and put them in the insurance company's pockets," because that's exactly what this bill does. The bill sponsor mentioned a couple of associations that have supported this. Those special interest groups do not represent our constituents. That's our job. We're here to take up for the people that don't have the millions of dollars to spend on lobbyists, marketing. We're here to take care of the people that elected us and put us down here to make the right decisions for them. So a lot of people spoke before me, and a lot of things were touched on. It's not going to lower insurance rates. Several states that have this have higher rates than we do. We've got a great economy in Arkansas, and I really think this is a bad piece of legislation. And I won't go into too many details. Senator Tucker did a great job lining out that this will affect, everybody, rape victims, victims of human trafficking. Those are the people we need to stand up for. We've got a choice here. On one side, we've got corporations, and on the other side, we've got our constituents. And I hope you will vote no and side with your constituents. Thank you.
Thank you, Senator Penzo. Senator Clarke, you're recognized to speak against. Oh, I'm sorry. Senator Bismayne. Okay.
Thank you, Governor. Colleagues, no, this is a long debate. I hope sometimes it's a mistake to be at the end. I hope you'll hear me. I have learned to my dismay in my time chairing judiciary that the courts are for the rich and big corporations. I'll be glad to debate anyone on that. I wish it weren't true. Being in the well today, I put a target on my back because of the industry that's within my district. The sponsors are sincere. They want to do something good. Those of you who are supporting this or think you're supporting this are sincere and you think you're doing something good. And when we hear tort reform, unlike Senator Scott, we jump, just like Senator Payton said. Let's go. In football, there's a reason we run reverses, and there's a reason we run screens, because if the other side's over anxious, we trick them and we take advantage of them. I can't blame you for supporting the bill because I did not know how I was going to vote until well into the committee meeting yesterday. Lobbyists, especially as chair of judiciary, lined up to visit with me, and I listened to them all, but I just didn't want to think about it. You know, we've got so many things going on, and I knew that this was a much deeper thing than what's on the surface. I knew I would think about it. I knew that I would get into it and give it everything that it deserved, but I just didn't want to. And so I listened to both sides, and both sides made good points. But as a person who makes a living buying, I know it is as important to listen to what is not said as to what is said. And I want to talk to you about some of the things that we did not hear. Because salesmen, if they've got something good, they're going to tell you about it. If they got a warranty, they're going to tell you about it. If they got a good record, they're going to tell you about it. If they've got facts, they're going to present them. And when they don't, that raises questions. We heard that several states, including Texas, have enacted legislation like this. Just as many have not. What we did not hear in 3.5 hours, and what I did not hear in all the lobbying, is how this has caused any improvements in any of those states. Never heard it once. No report of any decrease in insurance rates, just the opposite. No report how it even mitigated a rate increase. You know, how this, although rates went up, because I try to be fair, you know, even though rates went up, that this kind of helped them stay down. Didn't hear that. No reports that justice in tort suits was better. In these lawsuits and court cases, the goal is supposed to be to make the victim whole. As Senator Tucker brought out, if a jury awards more than the amount the judge that makes the victim whole, the judge is supposed to cut that judgment. You know how many of those judgments have been cut? 0. So I would, we heard about medical malpractice and the belief that this will help. Thanks to Senator Tucker, we heard that medical malpractice is 0.45% of tort cases. That's less than 0.5%. What we didn't hear is how this, in the states where this has been implemented, that it mitigated the price of malpractice insurance 1 cent. It's gone up. We did hear, when asked if this would lower insurance rates, from the experts who I happen to like, who were testifying for this. No. That was their answer. Can't tell you that insurance rates are going to go down. Victims don't want to sue. Why do people go to lawyers rather than accept the settlement they're offered? A lawyer in most cases is going to take a third. Let me tell you, in retail, that means you got to add 50% to what you were offered just to break even going to court. And you've been hurt. You've been damaged. You've been ill. You've been out of work. You don't want any more emotional turmoil. You don't want to wait. You need the money. So you've got to expect that you're going to get way more than 50% more than what the insurance company was willing to offer you, or you wouldn't do this. And if that wasn't the case, if that wasn't people's experience, they wouldn't continue to go to lawyers. These are victims. Their lives have been they've been gravely injured, and their life has been turned upside down. Many forever. Many don't get better. We can blame the trial lawyers, but let's pretend for just a moment there are no trial lawyers. Only the insurance company lawyers. You have a life-altering injury, you get offered pennies or dimes on the dollar for what you deserve and need and for what's happened in other cases, just like yours. Not one or two, hundreds, thousands. If there are no trial lawyers, you're in trouble because you get what you get. But folks, the folks who instead of offering common folks a fair settlement, force the victims to pay someone else a third of what they should get in order to get a fair settlement. It doesn't appear that they are fair at all, and yet they ask for fairness. That's their whole argument, fairness. Well, let me give you an idea of a bill that would be fair. A bill that indexed the offers that insurance companies have to make to actual settlements in actual court cases instead of lowballing. That'd be fair because most of y'all aren't here smart enough not to be lowballed, but how many people do you know that aren't good business people? The proponents said that this bill only affects one silo of cost, just medical damages. But yet it came out in testimony that in actuality, usually in these cases, if it involves medical damages, the whole thing is decided on medical damages. There's a formula that's used. And so when we lower medical damages, we have lowered whatever victim gets. And if that's what you want to do, and the idea that this will lower insurance rates, go ahead. I've already covered that maybe the victims are receiving too much. But not only has a judge not ruled that somebody was more than made whole, here's what we didn't hear. Not one case was presented from any state showing how the victim got a ridiculous amount of compensation. Not a graph showing thousands or hundreds or even dozens. Not 20, not 10, not one. You want to convince me? Show me how those of us paying insurance rates are suffering because these are settling way too high. It wasn't done. No facts, no statistics, no results, just leading us around with blind philosophy that we ought to be more fair. But when we offer settlements, at least according to what the victim finally gets, 2/3 of what, when the dust settles, wasn't fair at all. Oh well. I'm not even going to ask you to vote no. If you simply have not had the time and thought to really get down to the real truth, just vote present. Just say, you might have a good idea, but Senator Clarke raised some good questions and I'm not quite convinced yet. Come convince me. Trust me, if this doesn't pass, we'll see some version of it again. Thank you.
Thanks, Senator Clarke. Recognized to speak for, Senator Dismayne.
Thank you, Governor. I would agree with some of the discussion. I think we were trying to say, to me, something that is fairly simple and making it very complicated. And I do think that there has been a practice of utilizing the inflated number, the number that's not actually been paid for medical care, and part of the overall equation. And maybe that shouldn't be the practice. And that's probably where Senator Clarke and I would probably disagree, which is perfectly fine. But to me, the simple way to understand it is through an analogy, and so I'll just take Senator Payton, okay? You sell used cars, there's a price tag on that car, it may be $100. If someone comes in through a negotiation, whatever it may be, and they end up paying $60 for that car, right? If something goes wrong or whatever it may be, would you pay them $100 back? No. The value of that car is set at $60, not the $100 that was the price tag, but the $60 that was truly paid for that car. To me, that's the conversation that we're having. I don't think it's a whole lot more complicated than that. All of these other issues can still be reconciled to be able to make that individual whole. It doesn't prevent that. I think if I'm understanding Senator Clarke's discussion right, it's just been historically that this number that's not been actually paid but billed. Y'all look at all your insurance or your medical bills, you'll see it. This amount that's actually been at the top that not paid has been utilized as one of the components and multipliers for the other factors. And with that, again, I don't think this is an overly complicated subject. I understand the discussion. I understand there's angst about doing something different. And again, for that, I appreciate a good vote.
Senator Dismang, anyone else wish to speak on or against? Against, Senator Bryant, you're recognized.
Thank you, Governor. I would like to just echo what Senator Payton said. When somebody asks me about tort, my ears perk up. I'm listening. And whenever I was asked, am I for this? And I said, I'm struggling with it. The answer was much surprise to those that know how they think I would vote. But one thing that came out of testimony yesterday in judiciary was the thought about common law, and that this goes back to settled common law of 1854 when I looked it up. So that's how our state has been operating on this understanding, on this principle. So I consider that, if not a cornerstone of what we do and how we set policy and how we encourage industries to set rates, but definitely a foundational piece of that. And so while I am all for looking at addressing tort, we have built our house on collateral source. Built it. We've allowed industries to negotiate, to change structures, all upon what we have laid as settled law through common law of the foundation. So ask yourself, what happens whenever you remove the foundation of your house? Things start to collapse, crumble. If you set up the house knowing this is coming and anticipating it's going to happen, you've probably changed how you strategize and how you structure. And I believe that's what's been done, and that's what's being asked of us. So while all the debates for and against are excellent, and I think we need to continue the debates, I think this language goes too far. I'd appreciate a no vote. Thanks.
Thanks, Senator Bryant. Anyone else wish to speak on or for? Anyone wish to speak against? Senator Ervin, you're recognized to close.
Thank you. I appreciate all of the debate on this issue. I think I agree. It is based, we need to think about the reality we live in. I think that's what Senator Tucker said, the reality we live in. The reality we live in can't just ignore these contracts and these rates that are negotiated. You can't just ignore the example that Senator Dismang gave, the one that I gave in committee. If I go to Walmart and buy a $100 sweater, or Dillard's and buy a $100 sweater, and it's on sale for $50, and I only pay $50, I don't get to go back to Dillard's and say, hey, I bought it for $50, but you need to give me $100. That's not fair. It's not reasonable. And I would argue that, yes, we had this foundational principle in place, and the scales are unbalanced because that added weight is now here based on a 1998 court decision. That's what we're trying to rebalance, so we start at a fair and balanced position in weighing the evidence. One of the attorneys yesterday said, we need to base it on data and information that we can see and trust. I 100% agree. They spoke against the bill, but I agreed. The data and information that I can see and trust is, here's the receipt, here's what was paid, and so here is what you should be able to recover. As for unnecessary, necessary, that is current law. It's in the Supreme Court rules of what you're paying for is necessary. Why would you reimburse for something that's unnecessary? That's in Arkansas Supreme Court law. That's why those words are in this bill. This bill is very simple, and it is very easy to read, and it is not about all the arguments that have been put forward. It really is about exactly recovering only those costs actually paid by or on behalf of the plaintiff or that remain unpaid and for which the plaintiff or any third party is legally responsible. That is super simple and easy to read and understand, and that is all we're doing here today. None of those other categories are impacted by this legislation. You can seek and recover damages for pain and suffering. You can seek and recover damages for non-economic damages, lost wages, past and future, property damages, future medical costs as established by trial. Go after it. Great. Let's do that. And I would argue actually that if you actually decide and vote for this bill to create this fairness and this balance of what was actually rendered and actually paid, that it would actually maybe increase those other categories. You don't know. Juries wrangle with this every single day, and every case is different. What we're asking here today is the principle that the people I know I represent understand of what I paid for something is only what I should be able to recover. That is an easy, simple principle of fairness and balance, which is what our justice system is supposed to be about and what it was founded on. And with that, I'd appreciate a good vote. Thank you for the time. I appreciate your consideration.
Senator has closed. Madam Secretary, please call the roll. I would remind members to please speak loudly and clearly.
We have pairs at the desk. Senator Flippo, yes. Senator Sullivan, no. Senator Hill, yes. Senator King, no. Boyd? Yes. Bryant? No. Caldwell? No. Clarke? No. Crowell? Davis? Aye. Dees? Aye. Dismang? Aye. Dotson? Aye. English? Aye. Flippo, yes. Flowers? Gilmore? Yes. Hammer? Yes. Hester? Yes. Hickey? No. Hill, yes. Irving? Aye. Blake Johnson? Yes. Mark Johnson? No. King, no. Letting? No. Love? No. McKee? Aye. Murdoch? No. Payton? No. Penzo? No. Petty? Petty? Rice? Rice? Scott? No. Stone? Aye. Stubblefield? No. Sullivan? No. Tucker? No. Wallace? Aye.
Any senator who did not vote, wish to vote, or who wish to change your vote? Senator Rice? No. Any other senator, please check the board. Senator Petty? Yes. Any other senator? Wish to change your vote? Seeing no other, please cast up the ballot. By a vote of 18 yea, 17 nay, House Bill 1204 passes. Please return to the House.